The next case set for argument this morning is State of South Dakota versus Raymond Charles Banks. Christy Jones and Manuel DeCastro appear for the defendant. Ms. Jones will be arguing this morning. And Paul Swedelin appears on behalf of the State of South Dakota for Applee. Each attorney will have 15 minutes for your initial argument. And then Ms. Jones, you'll have a 5-minute rebuttal. So Ms. Jones, you may proceed with your argument at this time.
Good morning, Mr. Chief Justice, Associate Justices, Counsel. May it please the Court. My name is Christy Jones, and I, along with Manny DeCastro, represent Raymond Banks. The sole issue on appeal today before this Court is the trial court's prejudicial error in barring Raymond Banks from submitting a past polygraph test at his sentencing hearing, a hearing at which statute and case law has long held that the rules of evidence do not apply, and at which this Court's recent precedence affirms was a prejudicial error. If I may, I will give a brief rendition of the facts before I discuss the legal arguments. On February 26th of 2020, Casey Bonhurst was working for Domino's Pizza. He was delivering pizza on the east side of Sioux Falls. As he was walking back to his car, Casey Bonhurst was approached in an attempted robbery. A skirmish ensued, and ultimately, Casey Bonhurst was shot. The fact that Casey was murdered is not at issue here. The fact that Raymond Banks and co-defendant Jahennesy Bryant were at the scene, part of the murder and part of the attempted robbery, is also not at issue here. Both pled to manslaughter. However, who actually shot the gun is in dispute and was the main sentencing argument before the trial court. Within days of Casey's death, co-defendant Jahennesy Bryant was named and charged with his murder. The State of South Dakota used Raymond Banks' testimony to secure that indictment before the grand jury against Jahennesy Bryant. For 5 months of this case, Jahennesy Bryant remained the sole named defendant in Casey's murder. After 5 months, Raymond Banks was also included on a superseding indictment. During the entire pendency of this case, approximately a year and a half, the entire theory of the case remained that Jahennesy Bryant was the shooter and Raymond Banks was the backup for the robbery. Weeks before trial, co-defendant Bryant cut a cooperation deal with the state to plead to a cap of 25 years on the condition that he cooperate with the state to testify against Raymond Banks, who had originally pointed him to be the shooter, and on the condition that he submit to a polygraph test upon request. This was the first time that Jahennesy Bryant, the co-defendant, the original named defendant, ever made a statement that Banks actually shot Casey Bonhurst. Ultimately, as I stated, both co-defendants pled to manslaughter. However, the original defendant, co-defendant Bryant, walked into the sentencing hearing with a cap of 25 years in the prison. Co-defendant Banks walked in with a cap of 60. So the trial court at sentencing had to determine who actually was the shooter. It was a vital consideration.
Counsel, I understand that was certainly the argument that you were presenting to the court on behalf of the defendant. It appears when you read the court's pronouncement of the sentence, and it was a very lengthy, detailed, methodical pronouncement of the sentence, that the court started out with the premise that as a matter of law, both defendants are equally culpable, regardless of their actions, as aiding and abetting each other in this event. And the court acknowledged the different versions that were presented. And I don't know, and help me if you think it's there, but it didn't appear that in the end when the court pronounced sentence that the court then made a clear declaration that this is because he was the shooter.
Your Honor, I agree with that. I think the court did make statements that there could be evidence either way. However, the court did end up sentencing Raymond Banks to 60 years. So she gave him the maximum amount.
Of course, there were a lot of other factors that the court related as well. So how do we get to, and I do want you to talk about the admission issue, but how do we get to a prejudicial determination here? You kind of just made a statement, this is prejudicial. But I'd like you to explain a little bit more why you think it was.
I think it's because of the court's recent case law. In State versus Mitchell, this court has given strong language to a sentencing court when assessing a defendant that's before the court for sentencing. This court has given mandatory language to what a sentencing court should consider.
But your client was able to make the argument that he wasn't the shooter. So the mitigating evidence that you think was very, very important and was a centerpiece of your case, which I understand, you're able to present that.
You're right, Justice Salter. We did present that through argument. Raymond Banks gave a statement reflecting the same. However, that's entirely different than a third party coming in and giving an objective opinion about a lie detector test that he passed indicating he wasn't the shooter.
The linchpin for your argument in this regard is that the rules of evidence, as I understand it, don't apply. But does that necessarily mean that in the absence of the restrictions imposed by the rules of evidence, that everything necessarily comes in to a sentencing hearing without any regard for the judge's determination of whether it's helpful or reliable?
I do think that most everything under not only statute but this court's precedents does come in. The sentencing courts are required to consider a broad range of evidence to get the most full picture of who the defendant is and what happened.
But what if the court said, I'm not going to consider a particular piece of evidence, whether an aggravation or mitigation or whatever the case would be, because I just don't think it's reliable enough, and I just don't feel as though as a fact finder, which the court surely is at the sentencing hearing, I just don't think it's helpful, and I don't think it's reliable, and I have some concerns about it, so I'm not going to consider it. Do we review that? Is that abuse of discretion? Is that whatever? I mean, almost it seems like your view is, hey, if the rules of evidence don't apply, it's just automatically error to not consider it. But I'm not so sure that's right.
I think it's error to not allow the defense to present the argument. And I think what you're talking about is weight of the evidence. So I think that...
Well, you said you could present the argument. You said you were able to present the argument that he wasn't the shooter.
We submitted to the court that was our argument that he was not the shooter, which was wholly consistent with his testimony at grand jury. However, what we were prohibited from submitting was testimony from the person who took the lie detector test.
I understand that.
And the lie detector test itself. We were not able to do direct examination and have Mike Webb come in and testify about his process and the procedure and the reliability that he deems the lie detector to have. He was not subject to cross-examination from the state to point out maybe any weaknesses that could have been part of the test.
Has the technology advanced to such a degree that they're now generally acceptable in the scientific community? I mean, have we arrived at that point? When we look at what other courts of appeals are doing, it appears that they're affirming courts who are not permitting polygraphs to be admitted at sentencing hearings.
Your Honor, the reliability issue has not changed in the scientific field. However, the cases that talk specifically about the language you have just used talk about admitting a polygraph at trial. We agree. Had this been a trial, there would have been no polygraph. There would have been no mention of polygraph. There would have not been any admission of Mike Webb's testimony. There would not have been a request. It's different at sentencing. Because SDCL 1919-1101 says the rules of evidence do not apply at sentencing.
It doesn't say, though, that there's still not a premium placed upon reliable evidence. And why would the requirement to have reliable evidence or that standard of having reliable evidence differ or be fundamentally different from the standard at a trial?
Your Honor, I think the main point is the difference between having a jury be a fact finder and having a judge be familiar with what a polygraph examination is and to be able to weigh that evidence.
The rules of evidence don't make that distinction between a jury and a judge sitting as the fact finder. Indeed, the rules of evidence apply at trials whether they're tried to a court or tried to a jury. So that distinction may not be the one that turns it.
I disagree with that respectfully, Your Honor, because in State v. Hudel, this court upheld the admission of a PBT test, which I would like to talk about how that's entirely analogous to a polygraph test. But in that case specifically, the court cited the trial court's finding that he was familiar with the PBT, familiar with the reliability issues that are inherent in a PBT, and at sentencing he could consider that and give it the weight that he deemed appropriate. Your Honor, I think had Judge Howman accepted this polygraph examination and the testimony of Mike Webb into evidence at the sentencing hearing and said, I completely disregard this, I find it to be junk science, I'm not going to rely on it, I would not be here before the court today.
Well, in that event, then that goes to the question of whether you have any prejudicial error whatsoever.
And I think this court's case law directly is on point to that, considering not only was this mitigation evidence, but this went directly to Raymond Banks' credibility. If you recall, his testimony was secured at grand jury testifying that the other guy was the shooter.
Right, but if your argument is that all of this could have come in, the judge could have rejected it, and that would have neutralized the error, that effectively says the error wasn't so significant that it impacted the sentence.
I think the judge still has to consider the evidence. And I think this court's case law, recent case law in Mitchell, that says, again, mandatory language. This isn't permissive language.
But Mitchell also had a harmlessness component. In Mitchell we held there was error, there was a decision outside the range of permissible choices, and it mattered. It looked like it mattered. So we did assess that.
And Your Honor, I submit that this is not harmless error in that the trial court has to be able to assess that evidence. When Raymond Banks doesn't even get to present the evidence or the argument surrounding it, he's effectively prohibited from submitting additional information regarding not only his credibility, but his role in the offense. Who shot that gun is a vital question at sentencing, especially given the vast disparity between a 25-year sentence and a 60-year sentence. The trial court was placed in a position of determining who actually shot that gun, but yet prohibited Raymond Banks from offering relevant and persuasive, we would argue, testimony regarding that he was not the shooter.
You just indicated that the court should have received it, but then could have said, I disregard it because it's junk science. So what is there that precludes her from making that determination at the outset? This is junk science. We do not allow polygraph in evidence. Even though the rules of evidence don't apply in this, she could make the same determination. Why can't she control in her courtroom the information that she's going to receive when she knows that this is something that she is not going to consider from the get-go?
Because she didn't even hear the testimony of Mike Webb, who administered the test, who would have walked her through direct examination, would have walked through.
Did you proffer that information?
It was given to them, to the court prior to sentencing, a couple of days before sentencing.
So all the information, let me make a more precise question if I could. So all the information that you say supports your view that it was reliable and it was sound, and that was all proffered? Or just the results?
The results, his analysis, and I do believe it's in the record as well, his report that he had generated was given to the court beforehand. And I will note, this is not a person that the court is unfamiliar with. I believe the state even uses this particular examiner in some events. So the direct examination never happened because the court completely precluded us from presenting that evidence before we even got into the courtroom. The order was signed and we were prohibited from talking about it at all before a sentencing hearing was set, both for Bryant and Banks, that was televised, recorded, and set in motion before we could even get into the door to argue the direct examination questions that we would have asked Mr. Webb.
So on the question of error, what I understand, you're looking for not necessarily a rule from this court that says polygraphs have to come in at sentencing. What you're looking for is a rule that, or a decision from this court that says the court erred by treating a polygraph at sentencing just like it did just like it would in a trial.
Your Honor, I think under SDCL 1919-1101, I do think polygraphs come in at sentencing where a party submits
So
it.
you're saying you want a rule from this court, they automatically come in, the court cannot exclude a polygraph at sentencing?
I think the court can weigh the evidence as they do with a PBT, as they do with a report from a counselor, a report from or discharge summary from a chemical dependency assessor. I think they can give it the weight, but I think if there is a polygraph and either party wants to submit that polygraph, SDCL 1919-1101 is clear. The rules of evidence do not apply at that hearing. So I do think the parties get to argue that to the court.
There's actually not a rule of evidence that says polygraphs can't come in. That's the application of a rule of evidence. So I still don't understand how rolling back the rules of evidence affirmatively says, and therefore polygraphs categorically come in. You have to help me with that one.
Your Honor, the reason that we exclude polygraph evidence is because the rules of evidence prohibit it. The reliability issues surrounding polygraphs and PBTs, it's entirely consistent that these are unreliable. We don't use PBTs at trial because they're not reliable enough to put before a jury. We don't use polygraphs at trial. However, at sentencing hearings, routinely, and this court has upheld that PBTs can be talked about at a sentencing hearing and are around the state every day, disclosed to the court for sentencing purposes. That's no different than a polygraph examination. The reason that PBTs get to come in at trial or at sentencing hearings is because the rules of evidence that apply in a due process trial before a jury or a court are not the same once conviction has happened and we have switched over to a guilty party now being sentenced.
But the court is still the gatekeeper, surely, to make that initial determination as to what's relevant, what's reliable, what should be considered. And the court's ultimately the gatekeeper, and so your argument is it's an abuse of discretion?
I am arguing it as abuse of discretion.
And would a more robust proffer have strengthened your argument, namely the scientific literature, for example, establishing that the polygraph is reliable? Because as I referenced earlier, that it looks like the courts of appeals are routinely affirming courts who don't let these in at sentencing because of this reliability problem.
Well, and Justice Kern, I think that when we look at polygraphs as a whole, and even the trial court cited two separate footnotes that indicated here's a list of courts that allow polygraphs to come in, and here's a list of courts that don't. So I don't think that there is a settled rule. I do think, though, however—
Ms. Jones, I think you've answered the question. I'm going to stop you because I think your time's up, but you can certainly add what you want to add on rebuttal.
I believe that's it, and I will come back for rebuttal. Thank you, Your Honor.
Mr. Sweetland, you may proceed with your argument.
Thank you, Your Honor. May it please the court, counsel. In Bertram, this court decisively ruled that polygraph evidence is inadmissible in criminal proceedings. And Banks acknowledges this to be true and argues that the polygraph evidence should be admitted at sentencing as mitigating evidence of his alleged lesser role in the offense. But as Justice Kern pointed out, nothing's really changed since Bertram. Polygraphs are no more reliable now than they were at the time of the Bertram decision, and that was only 4 or 5 years ago. Banks does not argue that polygraph technology has improved. He instead argues that this polygraph evidence should be admitted at sentencing simply because the rules of evidence do not apply at sentencing. And while true, that does not make sentencing an evidentiary free-for-all. Evidence at sentencing must be relevant, must be probative, and polygraph evidence is neither. Banks's polygraph evidence is not relevant because in this case it doesn't matter who the shooter was, whether it was Banks or Bryant. For purposes of felony murder, the lookout is as criminally culpable as the shooter. And likewise, for purposes of first-degree manslaughter with a dangerous weapon, the lookout who aids and abets is as criminally liable as the shooter. So whether Banks was or was not the shooter is not relevant either to the crime he was charged with or the crime he was convicted of. And nor is the evidence in this particular case, or really in any case, probative. The polygraph was privately administered by a friendly examiner hired by Banks' own lawyers. And as this court found in Bertram, these kind of cozy polygraphs like Banks's are, quote, of extremely dubious probative value, end quote, because they are administered under non-adversarial conditions. So, though evidentiary rules don't apply at sentencing proceedings, polygraph evidence still is not able to meet the thresholds of relevance and probative value.
Well, although both are chargeable as principals, whether they aided or abetted or were the trigger man, so to speak, their sentences weren't the same. Ms. Jones's client got 60 years, in essence, with time suspended, and Mr. Bryant got 25 with time suspended. And so certainly the court had to make a determination at some level who was the shooter here. And so they didn't receive the same sentence for a variety of reasons, but it seems that it does have some probative value at some level.
Well, for purposes of the conviction, the mens rea for either crime doesn't matter, aiding, abetting, or as a principal. It's the same. If you participate in this event, you are as guilty whether you're the lookout or the shooter. I don't think that the court determined or even had to determine who was the shooter. They were both involved.
There were two plea bargains, and they both had caps in them. What was the nature of the caps? Was the court bound by the caps?
Well, I think the fact that's being overlooked here is the fact that Mr. Bryant cooperated and Mr. Banks didn't.
No, the question that I asked is, was the court bound by the caps?
No.
Okay, so the court wasn't restricted from giving more than 25 for the one defendant.
I think the court can go outside and say, no, I disagree with this, and I'm not going to abide by this plea agreement.
Counsel, when I read the plea hearing, it didn't appear the court was treating it that way.
I'm sorry, Your Honor?
When I read the transcript of the plea hearing did not appear that was the way the court was treating it. It sounded to me like the court was considering this to be a binding cap.
Okay, and the court can do that. But the reason for the discrepancy of the sentences is the fact that one person cooperated, one person told law enforcement what they wanted to know, and the other one didn't.
And
still hasn't.
There's not an argument here of unwarranted sentencing disparity among similarly situated defendants for that reason. Your argument is they're not similarly situated when one cooperates, one does not.
Correct. I think there's a very big difference. And, you know, if there's any forum in which it would seem that polygraph evidence should be and might even have to be admitted, it would be in a capital case sentencing. But even when more than a defendant's liberty is at stake, courts have consistently held that polygraph evidence is not admissible as mitigating evidence in even a capital case. And while Banks argues that capital case sentencings are a little different because they're conducted in a more trial-like fashion, that distinction doesn't really have a difference. As expressly pointed out in Hartman and Hinton, cases that are cited in the state's brief, the rules of evidence do not apply at capital sentencings either. In fact, it would be a grossly unconstitutional for capital defendants to be subject to higher evidentiary thresholds than non-capital defendants. But just as in non-capital cases, polygraph evidence is not considered relevant, probative, or admissible as mitigating evidence in capital cases. And as Justice Salter pointed out, it's not as though Banks was precluded from putting on his defense of Bryant being the shooter. Banks was able to introduce evidence of photos of Bryant holding the gun in a gangster rap pose. He was able to introduce evidence of statements made by Bryant to mutual acquaintances in which Bryant allegedly claimed to be the shooter. But Banks's mitigating evidence was outweighed by stronger aggravating evidence pointing to him as the shooter, which can account for the discrepancy in the sentences. The gun was given to Banks by a friend to facilitate a different crime. Once he had the gun, Banks started talking about using the gun to rob people. There are also photos of Banks holding the gun in these gangster poses. Banks actually fired the gun into a rival gang member's house a few days before the shooting in a drive-by shooting. Banks is on video stealing ammunition for the gun from a Shields store a couple days before the murder. Banks is the one who disposed of the gun after the murder. Banks told his girlfriend that he had shot Bonhorst in self-defense, not that he hadn't shot Bonhorst at all. And in lieu of a teardrop tattoo that inside prison signifies an inmate has killed somebody, Banks bragged about instead getting a tattoo of a pizza slice that would signify that he had killed Bonhorst. And that kind of attitude, again, Judge Kern can get to why Banks is sentenced more severely than Bryant. There's a certain indifference there that's rather chilling. But perhaps most convincing is the fact that the forensic evidence demonstrated that the entry wound was on the left side of Mr. Bonhorst's neck, which means that the shooter was right-handed. And Banks is right-handed, and Bryant is left-handed. So it's not as though it's really Bryant's word against Banks in terms of who was the shooter. The circumstantial evidence pointing to Banks is more abundant and is more convincing. But that's not to say that this court should endorse admitting polygraph evidence in cases where it is one defendant's word against another, or where the mens rea elements for a principal and an aider and abetter are different. It's still a matter of science, and barring advancements in the reliability of polygraph evidence and polygraph science, the Bertram rule should remain in force for both criminal trials and criminal sentencings. Unless the court has questions, I'll cede the remainder of my time.
Thank you, Mr. Sweetland.
Thank you.
Ms. Jones, you may proceed with your rebuttal argument.
Ms. Jones, is your rule, the rule that you seek, one for all seasons that applies equally to the prosecution? So, for instance, let's say there was a simple drug possession prosecution, the defendant pled guilty, and the state at sentencing wanted to introduce a written report, not live testimony, a written report of a narcotics detective with quadruple hearsay based upon the statements of unknown informants. Under your rule, because Rule 1101 says what it says, that comes in. If it comes in, the state then seeks a prison sentence, the defense seeks a probationary sentence, and the court ultimately says, you know what, since that came in, I was going to treat this as a simple drug possession case and sentence you to a probationary term. But in light of this report, quadruple hearsay and all, I'm convinced that this person is a drug dealer because that's what the written report says. And I can consider it because the rules of hearsay don't apply. And it makes a difference here, and I'm going to sentence this person to prison, not probation, and the decisive factor was the hearsay report. Your rule would permit that. Is that what you want?
Your Honor, I will submit to the court, it's not my rule, it's the statute. The statute says that the rules of evidence do not apply.
Is that the result that you anticipate, and is that something that you understand is the consequence?
I understand, Judge, that it opens the door to a vast amount of information coming in at a sentencing hearing. I will submit also to the court that that's why we trust judges to weigh that evidence appropriately. My assumption would be is the defense would argue emphatically against that triple hearsay statement. Argument would be put before the judge, and the judge could weigh that evidence appropriately. So courts hear that kind of information all the time. And I will note, back to Justice Kern, you had asked a question regarding prejudice. That happened. The state made statements like that at this sentencing hearing. If you go back and look at the trial transcript, The state put in hearsay statements. The state put in statements from other people that were not present. The state put in unqualified opinions about whether or not there was a right-handed shooter or a left-handed shooter. The state's not qualified to make those statements. They put in argument. The judge then has the ability, who has the autopsy report and can look and determine whether or not the state's argument is persuasive. Courts do that all the time. And I think the legislature was very clear in stating that the rules of evidence don't apply because we trust judges to be that filter. We don't trust a jury necessarily who's not legally trained, which is why the rules of evidence do apply at trial, and there are due process standards at trial that are different. However, once somebody has been convicted, or in this case pled, the rules of evidence simply don't apply. So the court is the filter for that kind of information.
Counsel, I think you had agreed in your opening remarks that we do review this for an abuse of discretion. Is that correct?
Yes, Your Honor.
So polygraph evidence does come with it a body of case law that has gone back years in a pronouncement by this court that it's per se inadmissible in civil and criminal cases. So when we review this matter for an abuse of discretion, even if this court were to adopt this very strict rule that you are advocating for here, given the body of case law that is in existence in South Dakota, and even if we want to look at the courts looking at surrounding jurisdictions, and it did appear that the weight of the authority that she was citing was against the admission of polygraph evidence, how would we find that this court at this hearing abused its discretion in deciding not to admit it with that backdrop?
Because, Your Honor, the cases that have cited the per se ineffective rule in what we argued below was those cases are at trial. So this court has not dealt with whether or not...
Well, so, I'm sorry, but say it's a case of first impression, and I think this may be the first time this issue has come before the court in the context of a sentencing hearing.
It is.
So when a court is facing this, you know, as a matter of first impression and trying to apply the law that is there, how would we find that as an abuse of discretion when there is no clear rule where this issue has been presented to the court?
While there's not a case specifically factually on point that this court has addressed, there's other statute and case law that courts know. Sentencing hearings are broad. Sentencing hearings, we hear a lot of information because we want the court to know the most about a defendant before them. So I do believe the court, and I would surmise sentencing courts are familiar with 11-1101, that the rules of sentencing, that the rules of evidence don't apply. So I think knowing that statute in and of itself is important. Additionally, in looking at the court's decision in denying this polygraph, most of the cases that were cited were at trial. And that is a huge distinction. This case has dealt with one case regarding a sentencing hearing request to enter a polygraph test, and that's State versus Stevenson. The court permitted the polygraph.
Ms. Jones, I'm going to stop you there. Your time is up.
Thank you, Your Honors.
Thank you. I want to thank both parties for your arguments this morning. The case is submitted and will be in recess for 5 minutes.